This is our session with Phil Dicomo, and he is a specialist in everything to do with legal issues, particularly has an expertise in nonprofit legal issues. Phil has been a guest presenter and speaker for us 2 years. Is it 2 years? I think it's 2 years in a row for Board Readiness, the program that we conduct every year in partnership with Lynn University. And we always bring Phil in to talk about the legal and compliance issues. So it's wonderful to have you with us today, Phil. I do want to just go into a little bit of Phil's background so that you all have an understanding of his expertise. So if you give me 1 second, I'm going to read you his bio. So Phil is a shareholder at Mason Yeager and serves as outside general counsel to both commercial and nonprofit organizations. His practice focuses on nonprofit governance, emerging companies, licensing, mergers and acquisitions, and executive employment matters. He's a Florida native and former broadcaster, and he brings over 15 years of media experience to his legal work. He holds the Chartered Advisor in Philanthropy, the CAP designation, and is widely recognized for his expertise in philanthropy and nonprofit strategy. And we will be sure to add a link to his company's website when we send out the recording with the slides so that you can all follow his company and follow their work. Phil, welcome. So good to have you with us.
Great to be here. I appreciate the opportunity to speak with everyone.
So before we jump in, I know we have, just to give everyone an idea of how we're going to do this today, we have some questions that I've put together, and I've given those to Phil to review in advance. They are specific questions that have come about in our board readiness sessions and questions that have been asked of our team over the past 6 to 12 months as well. So they're pretty robust, and they're good topics, I think, for us to be discussing. But we would also like to hear from you. The reason we're having this session is because one of our webinar attendees requested a nonprofit legal update. And whether it's bylaws, governance, the current situation, in the United States, 990s, and, what's happening in terms of algorithms and things like that. These are all things that we're going to be discussing. Charitable solicitations. What states should I be getting my charitable solicitation for? So all of these things are going to be discussed today, but please go ahead and put your questions in the chat. If you'd like to introduce yourself in the chat so that you can communicate with each other and, have some peer dialogue outside of the webinar, please do so. But put your questions in the chat. Tanaka is going to be monitoring. So we'll go through some of the initial questions, but we can stop at any time and address anything that's coming up for you that's important that we need to talk about. All righty? Great. So let's jump in. Let me go back to sharing my screen. All right. So the first question we have is, let's see if it shows up. There it is. Okay. What practical steps can nonprofits take to ensure that board decisions are mission aligned, especially when facing financial or operational challenges? And I think this is an important one, Phil, because we see this constantly, that there's a scramble to either course correct, adjust to current climate, adjust to maybe funding challenges. But how do we make sure that organizations are staying aligned with their mission? They're really ensuring that the board is actively engaged in keeping the organization focused on its mission.
Yeah, so this we literally were just talking about this just prior to the call. So on a regular basis, you're probably all doing some form of strategic planning that keeps your board engaged and keeps everyone aware of what the goals are, and how you're going to kind of move forward in a very strategic path. But oftentimes, and I've seen this with a number of clients recently with the new administration and some issues related to grant funding and federal funding. And I think that organizations either have been directly affected or indirectly affected. And so that's the kind of situation where, you know, you really, I think this question really becomes important. And, you know, one of the things that we were just talking about with Kirsten was a question that in light of these recent situations with government funding, uh, an issue that came up and a question that came up from a board when we were discussing balancing, do we continue with the program and risk losing funding, or do we get rid of the program and ensure that we continue the funding, is, you know, making decisions in light of your fiduciary obligations as directors. And a person who is a very intelligent director of many organizations, you know, said, well, but whom do I owe that fiduciary duty to? And I think that was a great question, because when you really break it down, you don't owe the duty to the organization itself or the members or the supporters of the organization. You really owe the fiduciary obligation to the exempt purpose for which the organization was granted its tax exempt status. You made a bargain with the government that in exchange for being tax exempt, we as an organization are going to fulfill these purposes. And ultimately, that's where your fiduciary duty lies. Um, so sometimes I think you have to remind board members, that's really who your duty is owed to. And then your directors have to make a decision based on that. And it's really difficult, given some of the circumstances that organizations have been put in. But I think that's the best advice I can tell you, is that you've got to make a decision based on what each individual believes is fulfilling their fiduciary obligation to the exempt purpose of the organization.
Do you have any examples, anything you've come across, Phil, that would be a good example of how this question comes up and how boards now need to make this decision?
Yeah, I mean, probably the best example is not one with my client, but one that you've all seen in the news, is the various universities who are having these discussions right now, and literally making decisions. Do we, you know, get rid of programs that we think are core to our purpose in order to keep the funding, or do we cut a deal essentially so that we can keep our funding? And that's a really difficult question to be able to answer, and no individual can make that decision, and people are going to come out with different answers. There have been, you know, directors who have decided to resign over questions like that, and you know, there are different levels of response. They're all really difficult to have to deal with that, but kind of in the biggest scale, that's the example that that we're clearly seeing. I have a board that's considering very entrepreneurial ways to exist, and I had a board member say at a board meeting, what we're doing is too important, and if we need to switch gears and become a for-profit entity to continue to do this in order to avoid the attacks, then that's what we should do. And I thought it was fascinating that you know, we were having that discussion, and he felt from a fiduciary standpoint that that was important, that the overriding mission was so important, and if we had to do it as a for-profit, then we would figure out a way to do that. I don't think that's where they're going, but I mean, it's just the conversations are fascinating.
Yeah, very interesting. Thank you. Thank you so much. Anyone have any specific questions about this? Has anything come up for you that you want to mention or want to ask about? All right. Okay, we'll move on to the next one. See if I can advance this. All right. Given the rise in strategic partnerships and nonprofit mergers post-COVID, what legal structures or precautions should organizations consider to protect their mission and exempt status during collaboration?
Yeah,
I think
so
this should be anyway, right? Regardless of where we are in our times, like what are the precautions that they should be considering?
yeah, I mean, so one of the basic things I talk to clients about is risk management generally. And when you think about risk management, the first tenet is always insurance, right? So
Mhm.
that's what people tend to think about. But the other tenets of risk management that quickly follow are, what I would call your structural considerations, and then, your documentation. So in documentation, I would include your agreements with other parties, and your policies and procedures. And so I think we tend to overlook those. And I think that when things are going really well or things are going really poorly is when you really should be focused on risk management. Because when things are going really well, chances are your tenets of risk management need to be reviewed and updated, including insurance,
Mm,
including agreements, policies, procedures, and maybe even structure. So for example, if things are going really well, and you have a social enterprise that is making a lot of money, and then there's a discussion as to whether does that social enterprise meet your exempt purpose, or are we going to have to pay unrelated business income tax? And if we're going to have to pay unrelated business income tax because we're being successful, it's not a bad thing. But do we get so much funding that we need to drop down a subsidiary and put that into a subsidiary? So, so just generally speaking, when things are going really well or things are changing, I think those are times when you need to look at risk management as a really key component of moving forward. And I think it's those three components. You probably spend a lot of time focusing on insurance,
mm-hmm,
and probably not enough time focusing on um, structure or documentation.
mm-hmm,
I had a fairly large client here, who we were talking about risk management, and we began the conversation, and we said, you have these social enterprises, and we probably want to drop them into separate LLCs that are wholly owned LLCs for risk management purposes. And right after we started it, a car crashed into one of their um, um, places of business, and it really brought home. There was some discussion among the board. Some board members thought, no, that's we don't want to do that. Why do we want to pay for these extra entities? And then they kind of had this experience where they were like, we need to do this today.
yeah,
So
yeah.
things happen.
When you say wholly owned subsidiaries or LLCs, you mean under the original 501(c)(3) structure, right?
Correct. So it's a
Can you
disregarded
explain?
entity.
Mm-hmm, mm-hmm,
Yeah, that uses the exempt status of the parent. And so when we form a wholly owned LLC, one of the things we want to do is not just use the state form on the Secretary of State website to form the LLC. We want to put specific language in the articles of organization that explain that this is a not-for-profit relying on the parent, and its sole purpose is to further the exempt purpose of the parent. One of the very simple reasons why you do that is because if that LLC happens to own property, for example, which is again a risk management. Let's put property in an LLC to separate liability. We want the property appraiser who's going to go on the website, who's going to go look up the deed and going to go look up your organization to explicitly see that this is still an exempt organization and it's still meeting the exempt purpose, so that you don't get the property appraiser knocking on your door and saying, "Oh, you owe us back taxes," right? So
mm-hmm,
so,
mm-hmm.
we're doing it for liability issues, but as we do it, we want to do it in a way that protects the organization across all facets.
And in terms of the benefit of having, as you stated, a property, we have actually someone on the call today that I know is going through a scenario like this. What is the benefit then of having a property, for example, under a wholly owned LLC that is within the 501(c)(3) structure?
Right. So the primary benefit from a risk management standpoint is to isolate any liabilities. So, a lot of times if we have organizations that, have endowed funds, we may consider putting those into a separate foundation to protect those from the operations. And part of it depends on the risk too. So if the property is um, a homeless shelter, there's a great deal of risk associated with that. So it makes perfect sense to put that into a separate entity, which by the way, could be a wholly owned LLC. In some cases, you might want to put it into a separate 501(c)(3), typically
Mhm.
structured as a supporting organization of the parent
Mm,
entity.
mhm,
But
mhm.
that's part of the, complexity of
Yeah,
determining what's the potential risk.
yeah.
Clearly, like I said, insurance is your first line of defense always.
Mhm.
But then structure becomes one of those components. And also, eh, furthering the concept in terms of risk management, um, when I talk about agreements, you shouldn't just sign every agreement, right? Like, there are times when you want the other party to indemnify you, right? And it may
Mhm.
not be in the agreement. So,
Mhm.
there's typically things that you can do from a risk management standpoint to protect you. The worst thing that happens for me is when a client comes to me and says, we signed this agreement and we think the other party breached, and here's the agreement we signed. And I was like, boy, I wish you would have given me this agreement before you signed it. Because you can't terminate, or, the breach provisions are so onerous that,
Mhm.
we've got to give them a chance to cure, and we've got to go through
Mhm.
loops. And so,
Mhm.
so part of risk management is also paying attention when you sign agreements, sign vendor agreements. And it's not really difficult. It's just, um, paying attention to it.
Yeah, absolutely. Okay, did we have a question on here? I thought I saw something come through.
Oh, just a
Okay,
comment, yeah.
great. Oh, Mail is taking notes. Excellent. Good for you. All right. Okay, so in your view, Phil, how can nonprofits effectively balance board engagement with governance integrity, particularly around practices like proxy voting or email-based decisions that risk fiduciary shortcuts?
Yeah, so we see it a lot where boards will take action by an email vote, and so it's really a state law issue, but it touches on your fiduciary obligations. So
Mhm.
under state law, so for example, I'm in Florida, right? So in Florida, there the way that a board can take action is they can hold a meeting. You have a quorum, you hold a meeting. The meeting can be in person or virtual, and you make a vote, right,
Mhm.
pursuant to following your bylaws. The other way is you do what's called a written consent or a written action, which is, you have the directors sign a document that says we're resolving to take this action. So an email vote is similar to a written action without a signature, right? You're just all responding to an email saying, yes, we agree. So, so my problem with that is similar to the problem with proxy voting. Um, for those of you who don't know, proxy voting is essentially where a director says, I'm giving my proxy to my fellow director to vote for me, right? And you see that in the shareholder context a lot, or if it's a membership nonprofit where members have voting rights.
Mhm.
Oftentimes state statutes allow members to vote by proxy. So there's really nothing wrong with that. However, for a director to vote by proxy, there's a good argument that the director is not exercising their fiduciary obligations when they're voting by proxy, because they're not participating in the discussion. They're not there to talk through it. They're not there to hear other people's viewpoints. And so therefore there's a good argument, and in some states there's been some case law on this that says that proxy voting is a breach of your fiduciary obligation. So the first question, is it allowed by your state statute? Most states either are silent or do not allow it. And then the next is there a better way to do it? And I would contend that having a meeting where everyone can participate, even if it's virtually by phone or Zoom video chat, is a better way to do it. And then secondly, if you feel like there's an urgency, and you need to get something done quickly, do a written consent. And again, written consents vary by state law. So a Florida organization would require unanimity. So every director would have to sign it. And that may sound cumbersome, but honestly, with DocuSign and software programs that we have right now, it's not that big of a deal. And what we find is, in the old days, if we sent around a written consent by email or by mail or personally, it could take a month to get it back.
Yeah.
When we send it by DocuSign, we usually get everyone's signature in the same day. So it's a much better way to do it. You don't put your board in harm's way by potentially having them breach their fiduciary obligation. And it's a simple way to get through the process. The other alternative, by the way, is if you need to have action taken quickly, depending on, again, your bylaws and your organization, your state law, is your executive committee can take the action on behalf of the full board. So that's the other way if you need something done quickly. And let's say you have 30 directors and you may not think you can get everyone to sign if you're in a state where you have to have unanimous consent. By the way, if you're a Delaware organization, for example, you only need a majority consent, but then you have to within 10 days send the written consent to every other director so they're on notice that it was enacted. So again, it depends on state law. States
Mhm.
like Florida require unanimous. States like Delaware, it can be a majority so long as you provide notice to the other directors. And then you have the option of doing an executive committee meeting in lieu of a full board. And this way you don't have issues with uh, putting your board in a position to, potentially be uncomfortable with violating their fiduciary obligations.
Okay, so just to summarize, no proxy voting if possible, right? We discourage that.
Yep.
We don't want email decisions because it doesn't really allow for the discussion. Plus the as you've said before, you don't know who that email is going to. You mentioned this once in our board readiness, but you're
That's
like, yeah, how do we know that it was you that actually opened the email and said yes and sent it through? So written consent, we would need unanimous in most states, or at least in the state of Florida, we know that. So is DocuSign one of the preferred mechanisms? So that one passes the fill test?
Yeah, that's right. And the reason is because they when you get a DocuSign signature, there's a tracker at the back and essentially they're
Mm-hmm.
validating the email.
Mm-hmm.
And so to your point, Kirsten, that when you just send an email to someone, they can come back later and say, well, I didn't respond. Yes, someone else might have done it. Maybe my
Mm-hmm.
son saw it and said, yes, it wasn't me. So you can't
Mm-hmm.
count it. So you don't want to leave yourself open to attack. And this obviously becomes critical when there's an important issue or an issue that becomes
Mm-hmm.
important later.
Mm-hmm.
And you'd be surprised how many times, I've been approached by organizations that said, our board did this, and now certain board members are attacking that vote. And, we'll go through, okay, did you follow the procedures? Did you, vote appropriately pursuant to your bylaws? Did you,
Mm-hmm.
vote? And so how open are you to attack because of that? It happens more
Right.
often than you would think.
Amazing. And then when you talked about an executive committee being able to take action, does this need to be in the bylaws that the executive committee, first of all, that there is an executive committee, a standing executive committee, and that they are empowered with making some of these decisions should it become necessary?
Yeah, so in most states, the answer is yes.
Okay.
That in most states, the not-for-profit acts provide
Mm,
that you can create an executive committee and the executive committee can take action in lieu of the board of directors. And you have to include that in your bylaws. And oftentimes there are things that are excluded from that action. So
mm-hmm.
in Florida, for example, an executive committee cannot approve changes to your bylaws. That has to be the full board.
Okay. Okay. And maybe after the session, you could just give us an example of where we would go in the state of Florida, and we can try and figure out for other states where people can go to find out the nonprofit law that would be applicable. Okay, fantastic, great. All right, anything else on this? Let's see.
Kirsten, you're not sharing
How
your
does-
screen, just letting you know.
Thank you.
Yeah.
That's fine. I wanted to kind of flip back and forth between seeing more of Phil and hearing some of his responses and then go back. But thank you very much. How does one address a situation where a board member negotiates funding from a potential donor, but the funds come with conditions that conflict with our mission and alter who we serve? Some board members believe we should accept the donation, leading to tension between the board and the founder/CEO. How can we navigate this disagreement while staying true to our core values? Dr. Roman, that is an awesome question.
Yeah, so that's a really difficult and often real life situation. And so, I mean, just to break down the components of it, so, a board member negotiates funding from a potential donor. So does the board member, have the authority to do that? Is there a CEO or a fundraising person or someone who participates in those discussions, and can they properly steer the negotiations in a way that avoids it to begin with? So kind of more strategic issues there. So the funds then come with the conditions that conflict with our mission and alter who we serve. So the legal term for that is ultra vires, which is essentially off of your mission. And so from a legal and best practice standpoint, what we would suggest is that you don't want to enter into agreements where you are going off mission. And there are a number of reasons for this. Some just from a strategic standpoint is that to the extent that you are doing things off mission because you've received funding for it, then you're probably taking resources away from your exempt purpose and those strategic initiatives that you've already set forth. So you're diluting your impact in the areas that you're supposed to be focusing on. Again, that's not really a legal argument, more of a strategic kind of best planning purposes argument. But ultra vires, from a legal standpoint, is a concern because to the extent that you waver from your primary purpose and mission to a great degree, you now are risking your exempt status altogether. So from an IRS standpoint, if you materially or substantially alter your exempt purpose, so you may be doing something that's great and good, but again, you made a bargain with the government to do something specific. And so does that things fit within your primary exempt purpose or not? And if not, then I would caution you that anything that you do that's outside of your exempt purpose endangers the organization. So, if I was providing advice to this board, that would be my advice: is they've got to be very cautious and careful about accepting gifts that are outside their purpose. Um, and I've seen organizations that have said, well, that may be so, but um, this may be a gift that may lead to another gift, and so we're going to do it anyway. And so, that's a decision again that the board's going to make. And I think there are a variety of reasons not to make that decision, but from a practical standpoint, I understand those decisions get made. And I think, that's where I think you need to kind of circle the wagons from a strategic planning standpoint.
And I think just the risk to the exempt status. I mean, that in itself, why trigger additional scrutiny? Why trigger an audit? Why jeopardize the status? I mean, then the thing is, so let's say that an organization is 4 or 5 years in and recognizes that they actually need to expand their scope, or they've decided in their strategic planning that in the next 3 to 5 years, they're going to add on some additional programming that were not explicitly laid out in their 1023 application form. What are the recourses there, Phil? What can they do if they say, legitimately, our board believes that we've identified some other gaps in what we're doing and we can actually meet those needs? What could they do?
Yeah, so I've had this come up a number of times, and so the very first thing we do is take a very long strategic look at, what was the exempt purpose that was given to the organization. How broad is it? How narrow is it? Can these things fit under that purpose? Can we make a good argument that these things fit nicely within the purpose that was provided? Oftentimes they can. And so in those situations, we will typically modify the purpose slightly, and when we report on the 990 in terms of what our organization does, we will include that. If it's more substantive and clearly outside the scope of the purpose, then we'll talk about alternatives, including potentially doing other organizations, setting up another entity, potentially doing a joint venture or a strategic partnership with another nonprofit, kind of fits that purpose better.
Okay.
Even doing it as a fiscal sponsorship project with another nonprofit. So there are ways to do it. It really depends on how varied and different the project is.
Yeah. Okay. All right. We'll do one more question from the chat, and then we'll go to a couple of the other questions on the slides. What are the most common legal pitfalls nonprofits face when partnering with schools or public institutions, and how can we proactively avoid them?
So the most common thing, honestly, is I see a lot of school board members or other elected officials who are on boards. And so in the state of Florida, particularly, or in states where you have sunshine laws and public record laws, it becomes a real issue, because if they're using their official email and receiving confidential information from the nonprofit, that information now has become public. So in Florida, where we have very robust sunshine laws, we always recommend that if someone who's an elected official or a member of the school board or even an employee at a public school is on your board of directors, that they use a personal email and they don't essentially don't serve in the capacity of their elected office, but as individuals. Um, and we've had real issues where the sensitive information has needed to be sent to board members who are particularly school board members in a recent case. But so that's one issue. You have that kind of tightrope with the public record laws and the sunshine laws in states like Florida, where you have those issues. The more common scenario is that, say, you provide after school programs for schools, and so you enter into contracts. One of the biggest issues is that governments don't or aren't required to indemnify the organizations that they have contracts with, and in many cases are legally protected. So anytime I negotiate an agreement with the government attorney says, "Oh, well, we can't indemnify you, period, because we're the government." And in Florida, that's not true. You can indemnify, there's just limits. So we always negotiate, and this is a good example of like risk management and where agreements take it into effect. So if you have after school programs with a school district or schools, don't just sign their agreement, negotiate to protect yourself. And the indemnification provision is one such provision. So for example, if you're doing after school programs in their facilities, they should indemnify you for issues related to their facilities, right? So in Florida, that indemnification is limited to $250,000. But let's say something happens and insurance doesn't cover all of it. That $250,000, could mean the difference between going out of business and staying in business for a small nonprofit. Those are some of the issues. I'm not sure if that touches on specific things that you were looking for, but
Yeah,
there's
no, that was, Lisa, is there anything else that you were thinking of specifically, or was that helpful? No. Okay, great. Wonderful. Thanks, Phil. All right, so let's go back. We'll go to the next question on the slide. All right, so Can you elaborate on best practices for organizations that operate in multiple states, particularly around solicitation compliance and the growing impact of the Charleston principles on digital fundraising?
Sure, absolutely. So for those of you who don't know, Charleston principles were a set of non-binding policies or guidelines that were established by the attorneys generals of states. So there's an active attorneys generals organization, and they got together and said, how are we going to deal with people who are fundraising online, but may not be in our state where we require them to register under our Solicitation Act. So the attorneys general got together and came up with the Charleston principles, which essentially state that, if you're established in a state and you're formed in a state, then you're required to register in that state to the extent that the state requires registration. If you're actively working in another state, to the extent that you would have to be registered in that state or qualified to do business under those laws, under the state qualification laws, then you should also register in those states where you should be qualified. To the extent that you're fundraising specifically to target people in a specific state, then you should register in those states as well. To the extent that you have a donation button on your website and you're based in Florida and people from Pennsylvania and New Jersey see your organization and want to contribute and then do contribute via the internet, you're not required to register in those states. So as of right now, we've got 42 states that require registration. District of Columbia requires registration. So most states require some level of registration. And if you're actively fundraising in those states, you should make sure that you're registered to the extent they have registration. The states that don't are typically kind of Midwestern states like, Montana and the
Texas.
Dakotas, things like that. Yeah, that's right. So,
Mhm.
um, so you really have to pay attention, particularly in the new world of online fundraising. So this includes if you're specifically targeting, emails to people in another state, then you're required to register in that state. If you're based in Florida, but you host an event in New York every year, then you're required to register in New York. So you have to pay attention to those, and the state solicitation acts are getting more sophisticated. They've got more requirements. So it's not just the registration process and the renewal every year now. Each state has their own requirements. Each state has commercial co-venture rules. Each state, um, most states now typically require a conflict of interest policy. Hopefully you have those anyway. Check the box with the IRS. Florida recently modified their act to require an audit if you've reached $1 million in fundraising revenue, and a financial review at $500,000. So, to the extent that you're in multiple states, you've really got to pay attention to each state's act and what's required depending on what activities you have in those states.
Mm-hmm. Absolutely. And then also the registration of a professional fundraising consultant, right? So
Correct.
Phil, can you speak to that a little bit? What defines a professional fundraising consultant for your organization? What
Yeah,
if it's a grant writer who's a ghost writer and just says, here, I wrote the content, and gives it back to the executive director, and the executive director submits, versus someone who's submitting on behalf of the org? What would be the nuances here that we need to look out for?
Yeah, so to the extent that it's someone on staff, then you're not required to register. And again, each state you've got to confirm for whatever states that you're in,
Mm-hmm.
and typically certain states are a little more robust than others. But if you're soliciting on behalf of an organization, then it's likely you're required to register in most states.
Mm-hmm. Mm-hmm. Okay. And you mentioned, for example, I'm familiar with the whole registration when you're having an event in another state because I've gone through that myself. What was interesting to me was that we also had to register as a foreign entity in that state first before they would even accept the charitable
Right.
solicitation registration. So it was
Yeah,
actually a two-step process.
you're right. And that depends on the state too, because some
Mm,
states might say, well, if you have an event here, you're not really doing business if it's a one-off.
right,
But many states, probably most states would, right?
would,
And then
exactly.
also too, you have to, particularly in places like New York or Palm Beach,
Mm-hmm.
if you hold an event in Mar-a-Lago, you've got to file with the town of Palm Beach, and their filing is very stringent. You have to do it well in
Mm,
advance. So, before you spend a ton of money on holding your event at Mar-a-Lago, you need to make sure you register with the town of Palm Beach. So there's even
that's
local
right.
requirements in certain parts of the country. So
Yeah, absolutely. Okay. Tanaka, you want to ask your question about grants? I think that's a good one.
Oh, yeah, I've just heard this a few times, people that are seeking grants from foundations that are in other states. Does that mean, since we're soliciting for that grant, does that mean we have to file?
so it depends on the state. I think most
Mhm.
states, so if you're soliciting a private foundation based in that state, and this foundation is based there, then technically you're soliciting in that state,
Mhm.
even if it's a grant.
Mhm.
I think this is a really fuzzy area though in a lot of states. So I'm not sure there's a lot of precise. I think if you read for most solicitation acts, if you read them, then you're technically soliciting.
Mhm. Mhm. Yeah, interesting. I wonder if the funders would have any knowledge or information or guidance to offer on that as
Yeah,
well.
it's interesting. I suspect that most of them would not want to even offer their opinion on it.
True.
The other issue that we see a lot of is when you use online vendors and portals for things like auctions and
Mm-hmm.
raffles and all of that. And one of the things that if you read those contracts before signing them is that they'll all state, we're not soliciting on your behalf. Even if they're soliciting, they'll state, we're not soliciting on your behalf. You're the solicitor. We're not the solicitor. You're required to comply with all laws. We're not required to comply with any law. And so they put it on the organization. And so you really have to be cautious of that. Because if whatever you're doing in multiple states with that vendor turns into solicitation, if the state comes knocking on your door, the party that you're paying to do all this work is immediately going to point to their agreement and say, well, it's not us, they're the solicitor, we're not doing anything.
Mm-hmm. Absolutely. Okay,
and,
great.
and there are some laws that are coming into effect in California and such to kind of point to those kind of online issues. But it's kind of early stage on that.
Mm-hmm. All right, next one. With increased IRS algorithmic scrutiny of 990 filings, what key red flags should nonprofit leaders be most vigilant about in their reporting and operations?
So I guess everyone probably remembers it's been a while now where the 990 IRS changed the 990 to ask all kinds of governance questions and get to provide more than have you provide more than just financials. And the IRS commissioner at the time said that he believed that there was a nexus between good governance and tax compliance. And so they then started asking all these questions. What he didn't tell us was that they also started to uh, create these algorithmic ways to review your 990s. So now all the 990s are electronically filed. Before they were even electronically filed, the IRS would scan in all 990s and they would run them through these algorithms. And the concept was we don't have as many auditors, and so we cannot conduct as many audits as we had in the past. So we're going to let technology do the audits for us. And what they've done is they've created the process of letter audit. So um, they'll run your 990s through these algorithms, and they'll look for red flags. So what they're looking for is any inconsistencies, for anything related to comp that may seem unusual, based on other answers that are in the 990. And then they'll send out a letter asking or inquiring, why did you do this, or why did you provide this answer, and can you explain it? Um, and they'll go back and forth a number of times. And typically, I forget the number, but I think something like 90% of the letter audits were all resolved. I think like 80% in the first letter, and then up to 90 something percent in the second letter. And that prevents them from having to send an audit team out, right? So just the IRS actually has become pretty efficient. So the number one thing is to be very clear and consistent with your 990. We check the box that says, yes, our board has reviewed it. Well, do that, like really do it, and have your auditors walk through with the board, and that little description box of what our organization does. Make sure that it makes sense for who you are and what you're doing, and make sure that you're really comfortable with your filing, because um, they're looking at your 990s more closely than ever before. And by the way, they started just with public charities, but now they're also doing private foundations. They've been doing private foundations for years now too. So
Okay, great. And then a couple of things that always catch my attention is the whistleblower policy, the document retention and destruction policies. I see a lot of CPAs just naturally defaulting to no, 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 no. When we do nonprofit formations, 501(c)(3) filings, we automatically include those. So I tell people, do you know how easy it is to just adopt this at your next board meeting? And you can either amend your bylaws and incorporate it, or you can have them as freestanding policies. But in my view, if it's being asked in the 990, best practice would dictate it would be good to have them. Maybe it's
yeah.
not a deal breaker, but good to have them.
And again, I really talk about these policies as part of your risk management strategy.
Mm,
It's there's three prongs to risk management: insurance, documentation,
Documentation.
and structure.
Yep.
And documentation means how you negotiate your agreements. It means you're having the proper policies in place, and it really matters.
Mhm.
Yesterday I did a presentation on AI policies for nonprofits, and there were 150 people who attended, and only 2 people raised their hands and said they had an AI policy in place. Now, this is an area that is new. When I drafted my first AI policy for a client, we didn't even call it a policy. We purposely decided to say, let's just call it guidelines, because this thing is changing so fast.
Mm,
We're going to have to revisit this like every couple of months.
mhm.
So we did guidelines. We actually, earlier this year, we just revised their policy to make it more of a fuller policy, because things have changed since we created those original guidelines. But a lot of the kind of the tech folks at this conference were saying, you really need that policy. You need to set these structures in place, because AI can be wild, wild west right now. So you really need to have that policy in place. And you also need to let your donors and your members and your stakeholders know that you're using AI, but you're using it in a conscientious way pursuant to a policy. And I thought that was really great advice. And from my standpoint, you have an AI policy because it's part of your risk management. At some point, it wouldn't surprise me if your insurance carriers are going to require it, right?
Mm,
The state may not, but your insurance carrier might. Um,
interesting.
so, again, I look at these, policies and procedures as part of your risk management protections.
Yep.
But as you said, Kirsten, it's easy to do right from the beginning. And I'm 100% in agreement with you. If you start out with it, then, the organization like is comfortable moving forward with it. And they'll tend to, continue to move forward and adopt, and improve the policies as the organization grows,
Right.
which is really what you need to do. But I think when you start out on the right foot, you tend to move forward with all those things in place. But it's never too late to kind of get on board and get those things adopted and to kind of understand why you need them, because that's really the key, is when you need them and something happens,
Right.
then they become really critical and important.
That's right. You have something to go back to and reference and say, no, this is our policy. This is how we handle things. So
Yep.
question for you, just speaking of policies, when we talk about conflict of interest and the 990 asks specifically, how is it enforced? How is that the use or the disclosure process for the conflict of interest policy handled at the organization? Is it acceptable? I know that at one point, the charitable solicitation registration in the state of Florida was requiring evidence of at least one representative of the board attesting to the fact that it was discussed annually at a board meeting, that there was opportunity for discussion of potential conflict of interest scenarios, and board members were asked to disclose any possible conflicts. What would your suggestion be for the simplest but compliant method of acknowledging on an annual basis or just ongoing basis? What's the best way to go about that?
So I always recommend you make it a part of your annual meeting, just because it's, typically most organizations have annual meetings, and, there's a set things that they do at that meeting, which is typically electing directors and officers. But I think if you just make it kind of rote part of your agenda for your annual meeting, that you're going to review your conflict policy and, go ahead and discuss it at that point. The other thing is, for all of these policies, a good governance committee is a great place for these policies to kind of sit and be considered and react to things in the real world or things that are happening to your organization, and say, hey, based on something that just happened, we think we need to modify our AI policy or modify our document retention policy. Maybe there was a change in a law that related to statutes or limitations. So, oftentimes there's outside forces that kind of force that. But if you make it something that is on your governance committee's agenda, then that's typically a good way. So with the conflict policy, I typically make it a part of the annual meeting, and I typically will write into the bylaws that the governance committee is going to review all the policies.
Okay, excellent. And on the election of directors and officers, I've recently come across a number of organizations that have not been having annual meetings, have not been sticking to terms, but they've said, you know what, we're ready to shape up. We recognize we haven't been doing this diligently in the past. What would be your suggestion for acknowledging that? I mean, maybe not acknowledging that they've been negligent, but sort of approving everything that's happened to date and just saying, all right, from this page forward, the board, there's a board resolution, the board has voted to ensure that there will be, whether it's every 2 years or every year, there'll be re-election of officers and directors. How can they sort of set things straight in their commitment to move forward?
Yeah, I've actually seen the same thing. And, a lot of times it's also come with, by the way, we started as a small volunteer organization, and we've kind of ignored it. And, we had this great group of people, but now we're getting larger and we're growing, and we need more directors, and, we need a different kind of director. And so, a lot of times what comes with that decision is, oh, by the way, we want to now have term limits. And so how do we kind of bring that in?
Mm-hmm.
And sometimes it's, having uh, different tiers of board members where they're staggered terms. So, that all to affect it, we need to revise the bylaws. So we start with typically a governance committee and revising the bylaws and having those discussions.
Yeah.
And often what it looks like is, so I would say more often than not, organizations have tended towards doing staggered terms. And then so the question is, okay, well, how do we affect that when, we have this guy who's been here 8 years, this guy's been here 10 years, this woman's been here 20 years. And so what we do is we say, let's start clean slate, as you said, and we're going to start from this point forward. And if we're going to do staggered terms, what we'll do is we'll affect them so that let's say it's 3-year terms and a third of the board rolls off every year for 3 years. So, oftentimes what we'll do is we'll like basically pick a name out of a hat to figure out who gets, the first tier, the second tier, and the third tier, knowing that, the first group will have only a 1-year term, the second group will have only a 2-year term, and the third group will have a full 3-year term.
Mm-hmm.
So typically what we build into the bylaws is for that first term, the term limit won't start for each person until they've had a full 3-year term.
Mm-hmm.
So the
Mm-hmm.
first 2 classes
Oh, I
essentially get a
see.
buy. Like they only have
I
a
see.
year
I
term,
like that.
but it doesn't count towards their term limit, right?
Right.
Yeah.
But that's great because it gives them the 3 years to gain the institutional knowledge. There's some continuity there in terms of
Right.
governance. Fantastic.
Yeah.
Okay.
Yeah.
I like that.
That's typically how we structure it. We'll modify the bylaws to do that, and then we'll say, okay,
Mm-hmm.
going forward, now each annual meeting, you're going to elect 1/3 of your board, starting with this class. B, you're going to elect your officers who are on 1-year terms. And
Yep.
then C, you're going to do your conflict of interest policy and review other policies.
Mm-hmm. Okay, I'm gonna mute honey, because I think that's where the sound was coming from. Sorry, honey. Okay, excellent. Thank you, Phil. All right, quick question, and then I want to see, we have 1 more minute, but I want to see if there are any other pressing questions in the chat. The AI policy presentation that you did, is there a recording of that? I know I saw it and I wasn't able to join, but is there a
Yep.
recording of it? Is it accessible to, for example, our
So
participants here?
there is no recording, unfortunately. That was the first question
Okay.
I asked because a number of people asked me, and it was a
Yeah,
half-day event, and there were a number of speakers. So unfortunately, they didn't have the ability to record it at the facility they were in.
okay.
So I mean, hopefully we'll do it again.
Okay, good. And then where do you suggest that organizations go for efficient, cost-effective support with policy creation, whether it's cybersecurity, whether it's AI policy? We're missing our document retention and destruction. Aside from using AI to help them create them, which is always a possibility, is there anywhere else that you can recommend?
So regarding AI specifically, I will tell you that I think it's Microsoft has a AI policy kind of framework,
Okay,
and you can actually take that and then um, use AI to personalize it for your organization.
great.
Um, my only caution with that is, I would suggest you have, a legal advisor, an attorney, someone on your board review it to make sure it's fully compliant. And then the other resource is, depending on where you are, local and state organizations, MSOs, and other nonprofit support organizations, in some cases, even community foundations have libraries that, might be able to provide some basic documentation. Some of the Council of Nonprofits, some organizations, provide, some basic, um, if not forms, some ways to kind of provide guidance on setting them up. So I think those are all good resources. In Palm Beach County, Florida, we have Nonprofits First, which for a very low membership fee has an entire resource of documents.
Okay, fantastic. And my apologies, I cut out for a minute there. Last question was, was this asked already by Holly's question? Is there a website that lists lawyers who can help with trademark filing for nonprofits, preferably pro bono or discounted? And this would be not just in Florida, but generally. Do you know?
Yeah, honestly, I'm not aware of any. I think there are some particularly artist organizations that have pro bono and low bono trademark services. I've seen that in the past. I don't have the websites, but you might be able to Google and find them. I will say, just real quickly, trademark is, to protect, your logo or your name. Copyright is to protect the written word or a song or, something that you author. The Copyright Office has come out with a whole um, guidance on using AI. So, you cannot copyright something that was created by AI. It has to be created by a human and use AI as a tool to help you write it, right?
Yes.
And when you write something, you own the copyright in that immediately, but you can register that copyright with the Library of Congress, additional protection.
Okay.
So
Okay.
that's just a real quick difference between copyright and trademark.
Thank you. Thank you for that. All right. Well, Phil Dicomo, amazing as always. Thank you so much for sharing your expertise with us. Absolutely. So valuable, so incredible. I'd like to know a little more about Nason Yeager and the availability of your services to nonprofits in the state of Florida. Or tell us a little bit more about the legal work that you do for nonprofits.
Sure, I appreciate that. Yeah, so we represent all kinds of organizations, small and large, private foundations, public charities, social welfare. We have a really great team, myself, my associate, paralegal, and an assistant who's really our client services person. And we can provide all kinds of services. I discount my rate, based on the type of nonprofit and whether it's something small or large, we're happy to assist. If it's federal law related, we can help organizations nationally. If it's state law related, specifically in Florida. And we're a full service firm, so one of the advantages for my clients here in Florida is that when they have real estate issues, I've got real estate attorneys who will work on it, and if we have a conflict and we have to go to litigation, I've got, litigators here. So it's nice to have kind of the full service of people to work with. And, even, we've had clients who have been given bequests. And so I got a whole trust and estate team that we work with and a tax team to navigate any really sticky issues that we get related to those. So, I to the extent you're in other parts of the country and need assistance, I'm on the American Bar Association's nonprofit law committee. So, I know attorneys in many other states who specialize in nonprofits. The one thing I would say is that a few years back, I was reminded of this recently. One of my colleagues published an article of things that attorneys on boards do wrong and we have to fix. And because if you have a personal injury attorney in your board, that doesn't mean they know nonprofit law or the IRS law. We all have tons of anecdotes of, clients who come to us and say, well, the attorney on our board or this pro bono attorney is for us. And we're like, oh, it's going to cost you a lot more money to fix this now because they didn't do it correctly. So the one thing I would say is, not you need to hire me for something, but don't make the mistake of relying on someone because they're cheaper and expensive.
Yes.
there's so much complexity because
Yes,
of the layers of law that we deal with in the nonprofit sector. So, just make sure you're protected.
excellent advice. Thank you, Phil. Phil, may we share your contact information in the chat?
Oh, sure. Yeah. Yep.
And remind me what your email address is. I'll just type it in here real quick.
Sure. Just P Dicomo
Yep.
at nasonjaeger.com.
And it's
YEAGER.
YEAGER.com. NASONYEAGER.com. All right, I just put that in the chat. Yeah, fantastic job. Thank you so much, Phil. Just a quick housekeeping note for everyone. Our next session is on nonprofit budgeting. So budgeting 101, everything from the planning to the execution. So you definitely want to be here for that. That's June 10th, Tuesday it's a Tuesday at 11 a.m. Alrighty. Thanks so much, everyone. Have a great
Thanks,
rest of your
everyone.
day. Thanks, Phil.
Bye.
Appreciate it.